Hail there, legal warriors. In this video, I'm going to cover the top 10 criminal justice blunders to avoid if you're facing a crime in Washington state. You need to avoid these costly blunders so you can get the best possible outcome in your case. If you're interested in the criminal law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington state for more than 20 years, and we're putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get the help they need. Now, this one's going to be a little harder on me because, as you know, I don't script these. As you could probably tell, I just sort of talk off the cuff. I do have a little bit of a cheat sheet here taped in front of me for the first time so I can remember the 10 blunders I came up with, but I'm still speaking contemporaneously off of each of these. So let's just jump into number one. Talking to the police without an attorney is costly mistake number one. Now, it seems obvious, but why should we not talk to the police? Why should we only talk to the police with an attorney? Because the police are not our friends if they're looking at us for a crime. It pays them to act like our friends. It pays like for them to try to convince us to talk. We just want to hear your side of the story, right? But you need to have an attorney with you if you're a suspect and you're talking to the police, because you need to be prepared. You need to be able to say what's important and don't say what can actually hurt us. And you need someone to make sure that you don't get lied to, that you don't get pushed around, that you don't get taken advantage of. So avoid costly mistake number one. Talking to the police without an attorney, universally a bad idea. If we're a suspect, they may make you think you're not a suspect. So, hey, if you get contacted by the police, good idea to say, hey, I always wanted to try to help, but I'm going to reach out to my local attorney first. How can I get back to you? That's your right. You don't have to talk to police. That's what you need to do. Mistake number two is misunderstanding your rights. Okay? That people think that, hey, if they don't read my Miranda rights, then whatever I say doesn't count. That's not true, okay? An officer, at least in Washington state, and I'm going to get a whole bunch of comments about all the junior lawyers out there all throughout the United States that's telling me little different things that might be true in different areas, might be their interpretation of a U.S. Supreme Court case. But bottom line is, think about Miranda rights like this. You only need to be read Miranda rights if you're suffering custodial interrogation. Custodial, your freedom restricted to a degree similar to formal arrest. Okay, now there's a billion cases out there where we can argue fact pattern by fact pattern if someone was in custody or not. Okay. That's why there's so many conflicting opinions. So feel free to share what you think it is in the comments. I'm not going to get into a debate because that's why there's hundreds and thousands of cases out there. And that's why the law is so inconsistent. But custodial, you need to be in custody, and it needs to be interrogation, asking you questions designed to lead to an incriminating response. So if you get pulled over for DUI and you're in your car and they start asking you how much you had to drink, you don't need to be read Miranda because you're not in custody. You're being interrogated. They're asking you to a question that could lead to an incriminating response. I've been drinking, officer. Only a couple, right? It's always only a couple. But you're not in custody. Similarly, if you've been arrested and you blurt out without being asked any questions, you haven't been read Miranda, you're arrested, and you say, well, I only hit her because she pushed me first. Well, you just admitted to hitting somebody. And if they didn't ask you a question that led to that answer, that's not interrogation. Now, there's a lot, we can argue all these fancy case law about whether or not they needed to read you Miranda and whether or not they were sort of hiding the ball. But the bottom line is, if we're not formally under arrest, then they can ask us all the questions we want. And for the most part, it doesn't matter if they read your Miranda rights. So many people, I didn't read my rights. No, they don't have to until they arrest you, until they intend to question you, as a rule of thumb. So, mistake number three, posting about your case on social media. How many times have I seen a prosecutor track down something on social media, or a police officer track down on something on social media for a potential new client, or someone calling me on the phone, or even a client where they're talking about what they did, where they're talking about the crime. I just egged, here's the photos of me egging this house. Don't do that, right? Don't uh, talk about your feelings about what happened in the criminal activity on your Facebook, on your Instagram. Don't tweet about it, right? Please, just keep it to yourself, because the government will go use that. We'll use it against the other side. We do it all the time. We have people on my staff that's going to search social media to try to find out, hey, is there something that this alleged victim said that makes his or her story less credible that they posted about? And when we find it, it's gold, and the prosecutors will run from that. And just like we'll run from it if the prosecutor has something, right? Because it's pretty powerful evidence. So don't create powerful evidence against you. Avoid that mistake. Mistake number 4. It sounds self-serving, but it's not, because it's really important. Choosing the wrong attorney, right? We may not be the right attorney for you, but don't choose the wrong attorney. You need to find an attorney who's knowledgeable in the local jurisdiction. They don't need to be in the same city, but I'm not taking a case over in Spokane because I'm too far away from Spokane. I don't go there enough that I would do the same type of job as someone who's over in that county. Okay, so find a criminal attorney, not a family law attorney, not your friend's attorney, not your uncle, not your parent, for God's sake. Find a criminal attorney that's highly rated. Read the reviews, right? Pay attention to how people feel when they talk. What's the emotion in the review? Did they feel well supported? Was the attorney always available? Were they judged? Look at those things, because the attorney is the one group of people, not only that can help save you, but can also help make it so you can sleep at night and make this process more tolerable. No one else is doing that in the system, right? No one's trying to be your friend except your attorney. And that's why it's a good idea sometimes to get a private attorney, because at least you get to choose. Public defenders can be very skilled and very awesome, but you don't choose them and they don't choose you, so there's less of a commitment in general, in my opinion. Mistake number 5, accepting a plea deal without considering all the options, right? Don't just go plead guilty to get it over with, right? Well, I thought it was like a traffic ticket. I'd just go say what happened. I thought the judge would just give me a fine and I'd be done. No, don't do that. Criminal convictions have collateral consequences, right? We want to try to avoid them. We would like to not, we don't go to jail. We still don't want a criminal conviction if we can avoid it, right? Could be harder to get a house, rent a home, lease a car, right? Get a job, right? Go to a field trip for your kids, chaperone at school, right? There's all these black and white things that can be complicated if we're convicted of a crime. Are you a non-citizen? We need to try to avoid it. Doesn't mean we always can, but we need to. So don't just enter a plea. There's alternative ways to get out of things. If you've watched my channel, there's SOC, stipulated order of continuances, compromise of misdemeanors. There's just factual defenses. There's mental health court and certain felonies, drug court, therapeutic alternatives to prosecution. If you're a juvenile, you can get a deferred disposition, on and on and on. So get that right attorney and don't just go plead guilty because it seems easy and you want to get it over with. Mistake number 6, not preparing for a court appearance, right? Be prepared. Know where to go. Know when you need to be there, and be there 15 minutes before that. If it's an online court, WebEx or Zoom, make sure you can do a WebEx or Zoom. Make sure you have the login the day before. My firm won't send it out 2 or 3 days ahead of time because it changes. Things change, right? So we'll give it to you the day ahead of time. But if you don't have us, some other firm, make sure you get that login, or the public defender. Be prepared. If you go to court, dress appropriately, right? No hats, no shorts if you can avoid it, no sleeveless shirts if you can avoid it. Try not to bring your kids if you can avoid it. If you're on Zoom, don't be walking around. Don't be driving your car. Don't be smoking or eating, right? Show some respect in court because people are watching us, right? And as you know, if you've seen my channel, if you're on Zoom, keep your camera off and yourself muted until they call your case unless the court has told you otherwise. So mistake 6 is not preparing for that court appearance, and part of being prepared is you can ask your attorney what to expect, right? Reduce your anxiety, but I'm talking about figuring out how to get there. So mistake number 7 is ignoring court conditions of release, right? What's a condition of release? I just had a video on that just 3 or 4 before this one, okay? A condition of release is where the court says, hey, defendant, I'm going to put certain restrictions on you while this case is going forward that you have to obey or I'm going to put you in jail. Hey, the restrictions are don't drink, don't drive without a license that might be, keep us updated of your address, don't commit a crime, stay in contact with your attorney, put a scram on so you don't drink, put an interlock in your car, post bail to get out of jail. Well, see what those are, right? And if you're don't have the copy of the conditions of release, get them from the court. Sometimes your attorney has them, sometimes they don't. Sometimes these courts mess things up when they don't get them to you, right? So you need to know what they are. If you don't know what they are, find out. That way you can't mess up. Because if you mess up a condition of release and the government finds out about it, what's going to happen? They're going to try to put you in jail, and that's not going to help you. So pay attention to those conditions of release. Do not ignore them. Number 8, big mistake. Usually it doesn't happen. Once in a while it does. Don't fail to disclose crucial information to your attorney. So that's a couple negatives. In other words, make sure you tell your attorney everything. If we put it that way, don't hold back the fact that, yes, in your DUI case, by the way, there was an empty bottle of Jack Daniels in the passenger seat and a red Solo cup sitting right there. That's something they need to know ahead of time, right? Don't fail to disclose something that's important, that, hey, there was a witness that saw me punch this person, but I didn't want to tell you because then you would think I'm a worse person. Now, we need to know, and what you tell your attorney, for the most part, unless something happens, it's confidential, okay? We need to know what's there so we can use all of our experience and our know-how to try to plan for what might come up against you and to mitigate against the bad things and to use the good things, right? Crucial stuff you may not even know is crucial that might help you, right? So try to tell your attorney everything and realize that if your attorney has any experience at all and they're not a total jerk, that they're not going to be judgmental. We've heard it all. We've seen it all. We forgive it all. That's our job, right? So, whatever you tell me, I know there's a reason, there's an explanation. There may not be an excuse, but we're not terrible people because we had a bad situation. That's just not how I see it. It's not how most anyone who's going to thrive in the criminal system will see it, because if they saw it that way, they would be a terrible job. They'd be prosecutors. So that's number 8. Number 9, mistake to avoid, is not taking the charges seriously enough, right? Hey, it's just going to be fine. I'm going to go in and I'll explain to the court what happened. It's like I said a little bit earlier, and I'm sure it'll just go away. It's not that serious, right? I didn't do anything that bad. I was only at 3 times the limit of fish I was supposed to have. That's not a big deal. Yeah, it's a big deal. You can go to jail for that, right? It's my first offense, theft. I'm sure I'll just get a slap on the wrist. No, maybe this court hates people charged with theft and puts them in jail all the time. When I was a prosecutor, when people tagged something, they were real surprised when they came into my court, because I was a young guy. I really didn't like people that destroyed other people's property with spray paint and things. So I was pretty harsh on them, way harsher than a normal prosecutor. So you need to take it seriously enough that you talk to an attorney and take steps to try to protect your future, because you've only got one future, and a criminal charge sadly can affect it very seriously. So don't just be laissez-faire about that, and then you'll be able to take advantage of whatever opportunities exist to help yourself get the result that you need. And finally, the opposite of that is mistake 10, is losing hope and giving up. Do not lose hope and give up, because thousands and thousands and thousands of people every month, and I'm sure, I don't even know the number, I bet it's hundreds of thousands of people are charged with a crime each year in Washington, and they're still here. They're still walking around, they still got jobs, they're still eating, they're still enjoying their family, all these things, because they didn't give up. They didn't lose hope and give up. You know, trust the positive instincts that you have to keep fighting, to keep pushing forward. Give yourself an identity statement, right? I am the type of person who perseveres. I am the type of person who carries on. I am a fighter. I am a winner. Whatever the identity statement is you need that advances you towards the goal, right? If you say all is lost and all is hopeless, you're going to disempower yourself to do anything good. You might need some counseling. You might need to read some books. You know, I'm always talking about the Four Agreements. It's a great book. The Obstacle is the Way is a great book. If we're feeling down, there's lots of things that we can go to try to not give up. And if you get a good attorney, it's your attorney's job to sort of help, hopefully, if they're emotionally intelligent, talk to you in a way that turns off some of that negative thinking. If we're clinically depressed, we need some medical help then, okay? But realize, let's look at it logically. If we're charged with a crime, it's not great, but we are going to get through it. We will. You will. And pretty much everyone does. So those are 10 mistakes to avoid, 10 pitfalls. Don't make those blunders and mess up your chances in your criminal case in the criminal justice system. So, you stayed with us. Thank you so much. That was a lot to listen to. Please like and please subscribe so more people can hear this. And more importantly, if you have a criminal matter, feel free to reach out to my firm. We'll listen to what happened. We'll identify a way forward, and we will be there for you. Thank you.